And next we have sentencing in People versus Joy Howell. Okay, good morning. And we're here for sentencing on a charge of operating while intoxicated, third offense. It's a 5-year statutory maximum. The advisory guideline range was scored at 0 to 6 months.
I've known Miss Howell for quite a while. She used to live downstate by me. She did have a serious alcohol problem. She has acknowledged that. She's never hid from it. She's done everything in her power to try and maintain her sobriety the last 14 years. She fought, because I was just alongside of her to try and get her driver's license back, which was not an easy thing, as you can imagine, with their history. She never gave up. She fought so hard, and she eventually, after 3 circuit court appeals, eventually she got her license back. So when I first found out about this case, I've been practicing over 30 years, and it takes a lot to kind of surprise me because we see so much. And I know court, not going to say how old the court is, but we look like we're kind of in the same range. But it really did shock me that my client had another criminal conviction or criminal charge here, which turned into a conviction, because she really has dedicated her life to maintaining her sobriety. It's not just lip service from her, because she has been doing it. Even though she got her license back, she didn't stop going to AA. She didn't stop running AA meetings. She didn't stop having a sponsor. She's continued all of that. And because it's part of her life. She knows that she needs to do that to maintain her sobriety. Been on bond for probably almost a year, since August. And in that time, before she was incarcerated in May, she was blowing 5 times a day. I understand she had issues with diluted tests, but as far as alcohol use, you're going to catch somebody if they're using 5 times a day. If they're blowing 5 times a day. She had over 1,000 tests where she was clean. I don't think she ever missed a test. She may have been a minute or 2 late. That's possible. But I believe she has maintained her sobriety while she's been on bond. She has taken this case extremely seriously, because she knows, based on her history, the court could easily throw the book at her, so to speak. But her guidelines are 0 to 6, which means she's in an intermediate cell, which means that she should get a probationary sentence. I know that she has a history, but it's over 14 years old. I know we had a brief discussion today at the bench. We're not using Ambien as an excuse to all this. We're just trying to explain, because I wanted an explanation as how could this happen, Joy? I was actually not very happy with her once I heard about this, but after talking to her about everything and talking to her son, and her son was living with her at the time because she lost her house in a fire. Her house was fire damaged and water damaged, and so she was living with her son. And her son, it's on her that there was alcohol in the house. There shouldn't have been any alcohol in the house. He didn't give it a second thought because she hadn't been drinking. I think the recommendation of probation, I think they factored all this in.
Ms. Howell, you don't have to make a statement today, but you are welcome to. Is there anything you want to tell me or no?
Yes, good morning, Your Honor. I can't tell you how remorseful I am for all my actions. Having long-term sobriety, I've been a very productive member of society. I've helped a lot of people. I've been involved in community service, my church. I was working. I really took care of myself. I believe I just fell short of the glory of God. And out there, I will keep my guard up, be on high alert, work the AA program diligently, following all the 12 steps and all my affairs, stay connected with my support group every day. I'm so grateful for them that I have them, and there will be no pause in my recovery, Your Honor. Thank you for listening.
Thank you. Ms. Carucci, any recommendations from the people?
Yes, Your Honor. Thank you. On August 26th of 2025 at 8 a.m. in the morning, the police observed defendant's vehicle all over the roads. Once pulled over, defendant stated she drank a glass of wine the night before, specifically at 11 p.m. She had slurred speech and poor balance motor skills and was at 0.095 and 0.097 on the breath test. She's 64 years old. She was 31 at the time of her first arrest. She has 2 prior felonies, 6 prior misdemeanors. She's been in jail twice, prison once, and on probation 3 times. She's currently unemployed with an associate's degree. Given her OWI history specifically, on her first OWI, she had 2 years probation in 1994. For the second, she had fines and costs only in 1994. For the third, she had 2 years probation and 5 days in jail in 2002. For the fourth, she had 60 days in jail with 2 years probation in 2008. And the last one was in 2012. She spent 18 months to 7 years in prison. Then she went 14 years without any criminal activity until now, this occurring in August of 2025. Her guidelines are 0 to 6 months. The PSI is recommending 90 days with credit for 60 days served and 18 months probation. Our recommendation is to exceed the guidelines. I don't believe that the guidelines reflect that this is her 6th OWI offense. The guidelines don't reflect same related offenses, and that she also had 6 bond violations during this case. She's experienced with being in jail and on probation and having these prior OWI cases. So certainly a dilute, I think, should be seen as positive for those. There's a lot of reporting discrepancies in the PSI as compared to the prior PSIs. It was mentioned in PSI that she had differences in how she disclosed her mental health, her physical health, prescriptions, and past use of history of alcohol and controlled substances. There was a discrepancy between the sentencing memo and the police report, where the sentencing memo said she had an empty glass of wine, saw she had an empty glass of wine, so assumed she drank it in the sentencing memo. But to the police, she told the police officer that she drank her last glass of wine at 11 p.m. specifically. I believe that the sentencing memo was unfair in kind of blaming her son for having alcohol in his own home. She was staying there. She needs to be responsible for staying sober, and certainly had to have felt the effects with slurred speech and poor balanced motor skills that the law enforcement officer was seeing at 8 a.m. And she made the decision to drive while having symptoms of consuming too much alcohol. The people believe that 9 months incarceration addresses this issue. It's half the time she served last time, but which takes into consideration the 14 years without criminal activity and the other positive notes and defendant sentencing memorandum. I also believe that probation should be a minimum of 2 years. It should certainly not go lower than what she's done in the many times in the past. Thank you.
Thank you. Ms. Howell, if you'd please stand for the court sentence. All right, Ms. Howell, you're 64 years old. You're a retired nurse operating while intoxicated, third offense. That's because the statute only goes as high as third offense. We don't have separate charges for fourth and fifth and sixth, but this is your true 6th time you stood in front of a judge being sentenced for drunk driving. As the prosecutor outlined, the first one was back in 1994, and then through 2012 was the last drunk driving behavior before this offense. For that last one, you went to prison. You were paroled in the spring of 2013, discharged in the fall of 2014, and then there's been more than a 10-year gap. 14 years of sobriety and involvement in the recovery community. You know, the things you said about your commitment to your recovery, those are, to some extent, those are some good statements, but if you're that involved in recovery, some of your statements, you know, weren't really on the mark. You know, to stand here today and say, there will be no pause in my recovery. You should know better than to make statements like that people who struggle with these alcohol issues, you know, some of them are my friends, and they never talk about, I'm never drinking again. They talk about, I'm not drinking today. They understand that this is a lifelong pernicious disease that you have, that you can put in remission, but it's not going to go away. And also, I'm not sure your statements today fully recognize the problem is not just your recovery and your use of alcohol, it's your decision to drive. Every single time you drive drunk, you could have killed somebody. You're a retired nurse, so that tells me you spent your career caring for other people. I mean, imagine if at your hands, somebody would be dead or maimed for life. A child, a parent, a grandparent. Those things happen on our roads every day in America because of people like you. That when you drink and drive, you may not be a bad person, but you're a dangerous person. And I'm not sure your statements here today really show me that you appreciate the danger to others of your behavior, not just the danger to your own recovery and progress, but it's that you're a danger to other people. So I think the prosecutor's right. The guidelines as they are in the statutes today, they do not take into account that if the same crime is committed over and over, prior offenses are taken into account. Here they aren't because there's a 10-year gap, and some of them don't score because they're the predicates for making it the third offense. But the fact that this is just a pattern of the same criminal behavior isn't adequately taken into account in the guidelines. So if I were to only look at that history, an upward departure is certainly warranted, and prison could even be warranted. And for a true sixth drunk driving, I have sent plenty of people to prison for their sixth drunk driving, regardless of if their guidelines call for prison or not, because sixth drunk drivings usually calls out very loudly for prison. Heck, your fifth drunk driving sent you to prison, so it should be no surprise to you that your sixth could also do the same thing. However, there are some mitigating factors that counsel against a prison sentence, and your attorney has ably set those forth today and in more detail in a written sentencing memorandum, particularly your 14 years of sobriety, your investment in the recovery community, some explanation for what would otherwise seem an inexplicable one-time relapse here, of the loss of your husband in recent years, the loss of your home, and the issue with the alcohol in your son's home. And none of those are excuses, and they weren't presented as such, but they do explain what's going on in your life, and particularly that gap in time is compelling as well. So I agree with the prosecution that an upward departure is warranted. So I'm going to place you on probation as recommended by the Department of Corrections. I'm going to place you on probation for a 24-month term, so 2 years probation. And although the guidelines are 0 to 6, I've outlined not only a reasonable basis for incarceration, but also, I believe, for an upward departure. And I will, as the prosecutor has requested, order that you serve 9 months in the Sheboygan County Jail.
Regarding her driver's license, I think that's through the Secretary of State, but it would be a year. It would be whatever the Secretary of State says.
Yeah. We'll just, as to condition 19, it'll just say you must not drive a motor vehicle while your driver's license is suspended. It'll be suspended per Secretary of State. I don't know if it's going to be a year or not. It's probably going to treat it like the first.
They are, Your Honor.
Yeah.
Yeah, she's already been suspended.
Okay. So yeah, if it's suspended, you can't drive.
I'm sorry, your audio says I need to contact probation within 24 hours?
Of your
Once you are
release.
released.
Yeah. Once you get out of jail,
Oh.
within
okay,
24
yeah.
hours of being out of jail, meaning when you get out of jail, it's not their job to track you down.
Right, exactly.
It's your job to report to them.
All right.
Okay. Anything further from the people?
There, thank you.
Okay. Good luck to you.
After 14 years of sobriety, retired nurse Joy Howell returned to court facing her 6th drunk driving conviction. Her attorney highlighted her dedication to recovery, while prosecutors stressed the danger of repeated offenses. The judge balanced accountability with compassion, ultimately sentencing her to 9 months in jail and 2 years of probation, emphasizing that every decision to drive impaired puts innocent lives at risk.